2023 CR 451, State v. William Charles Parish.
Yes.
Your Honor, I believe you still have the plea sheet. After
I do.
discussing with Mr. Parish, he relays that it's his wish to enter that.
What happens when an elderly man faces sexual battery charges against his own home healthcare worker, but claims it's all in her head? Today, we're witnessing William Charles Parish in a Tennessee courtroom, wrestling with a plea deal that could save him from felony charges. But there's a catch. He has to admit to something he swears he didn't do. Will he take 30 days in jail to avoid risking years in prison? Or will his pride and proclaimed innocence push him to trial? This is the moment where principle meets pragmatism, and the stakes couldn't be higher. Let's see how this unfolds.
To enter that agreement.
Yes, it is.
You still want to go forward with this agreement?
Yes, sir.
All right. I do not recall exactly where I was, but I think the point is this. Do you understand that all of the rights that I've explained to you up to this point? You
Yes, I
understand,
do.
You understand that by entering this plea of no contest, you're waiving your right to a trial and to an appeal? You
Yes,
understand
sir.
that? You understand that's going to result in a conviction that's going to be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime?
Yes, sir.
You understand that by entering this plea, you're waiving all your rights that I've explained thus far?
Yes, sir.
Do you wish to plead no contest according to this agreement?
Yes, sir.
Is your decision to plead no contest today voluntary?
Yes, sir.
You understand I can't accept your plea unless I'm satisfied that there's facts to support it and that you are, in fact, guilty of these charges despite the fact that you're not admitting anything.
Yes, sir.
All right, listen as the state tells me what their evidence would be if this case went to trial.
Your Honor, the state would present evidence if this went to trial with Miss Phillips, who was his home health care worker. She would testify under oath that Mr. Parish grabbed her breast while she was there working with him on December the 13th of 2023. This was at his home within Dixon County.
Let's pause here because this is crucial. The prosecution's case hinges entirely on the testimony of one witness, the home healthcare worker, Sonia Phillips. She alleges Parish grabbed her breast while she was working in his home. No mention of other witnesses, no physical evidence presented, just her word against his. This is what makes these cases so complex. It's a credibility contest. Parish was originally charged with sexual battery, which is a felony that could land him in state prison. But through plea negotiations, they're offering to reduce it to simple assault, a misdemeanor. The difference? Instead of potentially years in prison and sex offender registration, he's looking at 30 days in county jail. That's a massive reduction, which raises a question. Is the prosecution's case weak, or are they showing mercy to an elderly defendant? What would you do in his shoes?
I'm not asking that you agree with those facts, Mr. Parish, but do you understand that's what the state would try to prove at trial?
I understand it.
All right. You still wish to plead no contest under this agreement?
Yes.
Are you satisfied with your attorney's services?
Yes.
You feel like Mr. Howard has done a good job of representing you competently?
Yes, sir.
Mr. Howard, do you know of any reason he should not enter this plea?
No, sir.
Then William C. Parish, in docket number 2023 CR 451, upon your plea of no contest to count one, an amended charge of simple assault, I find you guilty, sentence you to 11 months and 29 days in a county jail that will be suspended after you serve 30 days in jail. That you will report to jail on February the 17th, 2025 at 5 p.m. You're to have no contact with Sonia Phillips or her immediate family. That's the judgment of the court. He needs to see the probation department before he leaves today so that he can be on probation after he's released from jail.
Thank you, Judge.
Are we ready on the Patricia Kelly sentencing hearing? That would seem to be the next thing we are ready to take up.
Reached a resolution of this case.
I'm sorry, repeat that.
Subject to the court's approval, we've reached a resolution in this case in which Mr. Parish would be pleading no contest to an amended count one that will be amended to simple assault. He will be sentenced to 11 months, 29 days, suspended to supervised probation. After 30 days to serve, there should be no contact with Sonia Phillips or her immediate family. and he is to report to jail on February the 17th at 5 p.m. He does have about 6 days credit already on this year.
All right, Mr. Parrish, raise your right hand and let's place you under oath.
I will.
State your full name for the record.
William Charles Parish.
Mr. Parrish, you are here today charged with the offense of sexual battery. It's been indicated that you're going to enter a plea of no contest to an amended charge of simple assault, but have you seen or been shown a copy of those charges and talked them over with Mr. Howard? You and he discussed the range of punishment you're facing as well as any possible defenses you might have.
Well, that bothered me a second ago when I heard 11 months.
Probation charge.
Oh, okay.
It is a misdemeanor. It is a misdemeanor. A Class A misdemeanor carries a range of punishment of 11 months and 29 days in the county jail. Your sentence will be 11 months and 29 days in the county jail, suspended after you've served 30 days with credit for time served. You
Okay,
understand
now
that?
I got it.
All
Yeah,
right.
I got it.
Notice that confusion? Parrish just had a mini panic attack thinking he was getting 11 months of actual jail time, not probation. This is a critical teaching moment about how plea deals work. The judge is sentencing him to the maximum for a Class A misdemeanor, 11 months and 29 days, but suspending most of it. He only serves 30 days, and with 6 days credit for time already served, that's just 24 actual days behind bars. The rest hangs over his head during probation. If he violates probation, boom, he could serve the entire 11 months. This suspended sentence structure is designed to keep defendants in line after release. It's the legal equivalent of holding a sword over someone's head. The judge is now going through what's called a plea colloquy, making absolutely sure Parrish understands what he's giving up, because an uninformed plea can be thrown out on appeal.
I got it.
Do you understand that you have a right to plead not guilty to this charge and to have a speedy and public trial by jury in this case?
I understand it.
Do you understand you would have the right to have a lawyer and have one appointed as we've done with the public defender? I need you to answer out
Yes.
loud. Do you understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors? And
Yes.
their verdict would have to be unanimous before you could be convicted.
Yes.
Do you understand you and Mr. Howard could confront and cross-examine all witnesses called by the state at trial, and you can bring in your own witnesses by using a subpoena?
Yes.
Do you understand you would be presumed to be innocent at trial? You would not have to testify or prove anything, and no inference of guilt would arise because you did not testify at your own trial.
Yes.
Do you understand if you went to trial and you were found guilty, you could appeal that conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
Do you understand that by entering this plea, you are waiving your right to a trial and to an appeal? All I'm going to do is approve what your lawyers worked out.
Yes.
Do you understand that's going to result in a misdemeanor conviction, and that conviction will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime?
Right.
Do you understand everything I've explained to you thus far?
Yes.
Do you wish to waive your right to a trial and to an appeal and plea no contest according to this agreement? In other words, do you want to take this deal that your lawyers worked out?
Yeah, it's just being muddled over. The part I'm having a problem with is that I never did any of this.
Okay.
It's all in their head.
Well, then
So
we'll let
I'm
you-
having trouble with,
Stop the presses. This is the pivotal moment. Parrish just admitted on record that he never did any of this and says it's all in their head. He's essentially proclaiming his innocence while trying to take a plea deal. This creates a massive problem. Judges typically can't accept a plea from someone who maintains their innocence. That's why no contest pleas exist. You're not admitting guilt, just not contesting the charges. But Parrish is going further, actively denying it happened. The judge now has to make a choice: reject the plea and force a trial, or try to salvage this deal. Watch how quickly the prosecutor jumps in with the ultimatum. They know Parrish is wavering, and they're about to play hardball. This is psychological chess at its finest.
Mr. Parrish is set for trial the 22nd of this month. If you don't want to accept this plea, I'm fine with that. We will take this plea off the table and we'll put you to trial on the sexual battery, a felony, on the 22nd day of this month. This is an agreement that changes the nature of that, but it only works if you agree to it. Step aside and talk to your lawyer, make sure you're satisfied with this. Mr. Howard, as you know, I won't accept it unless I'm satisfied he's
And there you have it, the ultimate courtroom pressure cooker. William Charles Parish faced an impossible choice. Maintain his innocence and risk a felony sexual battery conviction at trial in just days, or swallow his pride, take the no-contest plea to misdemeanor assault, and serve 30 days in jail. The prosecutor's ultimatum was crystal clear. Take it or leave it, but decide now. This case perfectly illustrates the harsh reality of plea bargaining in America. Even innocent people sometimes plead guilty or no contest because the risk of trial is too great. Parish was looking at potential years in prison and sex offender registration versus less than a month in county jail. That's not really a choice. It's legal coercion. The most telling moment? When Parish said, "I never did any of this." Yet he's likely going to take the deal anyway. This is why 95% of criminal cases end in plea deals, not trials. The system is designed to pressure defendants into accepting deals, guilty or not. Did Parish make the right choice? Would you have risked a felony trial to maintain your innocence, or taken the sure thing of 30 days? Let us know in the comments below. If this case shocked you as much as it did us, smash that like button right now. Share this video with anyone who thinks the justice system is black and white, because cases like this prove it's all shades of gray. And if you want more raw, unfiltered courtroom drama with expert commentary, hit that subscribe button and ring the notification bell. We drop new cases every week that will challenge everything you think you know about justice. Until next time, stay informed, stay critical, and we'll see you in the next breakdown.